Morning.
Morning.
Okay, Monteiro Roberts, can you hear me?
Yes, ma'am.
On the record in the matter of the people of the state of Michigan versus Monteiro Roberts. This is file number 21-02404FY. Counsel cancel, please.
Chris Martin for the people.
Thank you. Mr. Roberts, today was the date that was set for your preliminary examination. As you would recall, at the time of the last court date that we were here, there was some concerns about your attorney communicating with you and his ability to do so due to underlying or a pending health concern that he had. The court has since received a motion from you requesting withdrawal of counsel, but we've also had your counsel join in that motion, indicating that there's been a severe breakdown between the two of you, and there's no way for that to be restored in order for him to provide effective assistance to counsel. So the court has granted your motion to have him withdraw as your attorney, and you'll have new counsel appointed to represent you, okay?
Yes, ma'am.
I can't give you an update at this time as to what's going on at the public defender's office, but as soon as someone provides us with some information, we'll make sure you're made aware of that, okay, sir?
Yes, ma'am.
Do you have any questions today?
No, ma'am.
I'm going to reset your matter for a new probable cause conference and a new preliminary examination date to make sure that you get new counsel and that they get the discovery, okay?
Yes, ma'am.
PCC. You reset it already? Oh, you did. I have you set for probable cause conference on December 2nd at 1 p.m. And then your preliminary examination is scheduled for December 10th at 9, okay?
Yes, ma'am.
Do you have any questions today, sir?
No, ma'am.
Any additional matters for the record?
May I put a couple things on the record, Your Honor?
You may.
First off, Mr. Laxton informed me that Mr. Roberts had filed this motion with the court, and I still have not received a copy of that, so I would like to have that for our records. Secondarily, this delay in the proceedings was caused entirely by Mr. Roberts' motion and the change of counsel. And we just like the record to reflect that for purposes of speedy trial and the 180-day rule, that this adjournment was occasioned by the actions of the defendant, and if the people were required to proceed today, we could do so. We had all of our witnesses under subpoena prepared to be here.
Thank you, and that is noted here. And it's without dispute from the court's perspective that any delay in moving forward, even from the date of arraignment, has been on the part of the defense.
Thank you, Your Honor.
Thank you. Okay, any other matters or questions for today, Mr. Roberts?
No, ma'am.
Thank you, you're all set for today.
Thank you.
Okay, Mr. Abbott. I don't know.
Have a good day.
Same to you. Hi, who's in the Ingham County Jail?
Yes,
What's your name, sir?
Eugene Burton.
Good morning, Your Honor. Screen. He's my client.
Him? Mr. Green?
Yes, good morning, Your Honor.
I'm wondering if you need to speak to him privately.
No, I met with him out the jail the other day, Your Honor. Thank you.
Okay, thank you. Anyway, we can see if we can track down Mr. Abbott for Dakota Martin. Let me see if he's, I don't know if he's in maybe another courtroom.
He's down the Buchanan Hall.
Okay, sounds good. Okay, we're on the record in the matter of the people of the state of Michigan versus Eugene Burton. File number is 21-02800. Council appearance.
Thank you, Your Honor. Aaron Husfield on behalf of the people.
Good morning, Your Honor. Vince on behalf of the defendant, Eugene Burton, who's appearing by Zoom at the Ingham County Jail.
It was a date that was scheduled for a probable cause conference. Are we continuing to examine this?
Your Honor, I can address that. I talked to Ms. Housefield yesterday. We are continuing it on for a prelim, but I know it's scheduled for next Wednesday, and we will be traveling for the holidays that day. In fact, we'll be leaving Tuesday.
Okay, so we need to waive the 21 days so that you can get a new date, correct?
That is correct, Your Honor.
Okay. Is there an objection to that at all?
No, Your Honor. Thank you.
Mr. Burton, you have the constitutional right to have a preliminary examination within 21 days of your arraignment date. You were arraigned back on the 8th of November. Your exam is set for November 24th, which is the day before Thanksgiving, and your attorney is scheduled to travel for the holiday. And so because of that, there's a request to adjourn this matter. You'll still have your examination. It just won't be on the 24th. You understand that?
Yes, ma'am.
Okay, and you're willing to waive the 21-day timeline to get a new date for your exam?
Yes, ma'am.
Okay. Can you do December 2nd, Mr. Green?
December 2nd, let's see. Yeah, I've got it 11 o'clock in front of Judge Cunningham. So yeah, December 2nd should work.
It'll be at 9:30.
That'd be fine, Your Honor. Perfect, yeah.
Okay, sounds good. We'll reset this for December 2nd at 9:30. Any additional matters for the record?
Nothing for the people. Thank you.
I would like to address bond if I could, Your Honor.
You can.
Mr. Burton was arraigned, as the court indicated. I was present at the arraignment by Zoom. I think the magistrate arraigned him and gave him a bond of $100,000 cash as surety. We think, I respect the magistrate. I've done a lot of business with her over the years, but we feel that excessive. Although Mr. Burton had priors in the past that are serious, we did address that at the arraignment. He has contacted the community. He's lived here in Ingham County his whole life. He is currently married to Bianca Hall. They've been married over a year. She has no criminal history from what I understand. He has two girls, teenagers, 16 and 17, two stepsons he does take care of, 8 and 11 from Miss Hall. And Miss Hall is currently pregnant by Mr. Burton with their first child together. We know there are serious charges, but the day he was arraigned, he was supposed to start a new job, a very good job from what I understand. He does have opportunity for work if he is released on a reasonable bond. And so we would ask the court to strongly reconsider his bond off the $100,000 cash as surety, so he can get to work and continue supporting his family. I've been retained in this matter, and he is absolutely no flight risk to the community and he will be at court on December 2nd. Thank you, Your Honor.
Thank you, Madam Prosecutor.
Thank you, Your Honor. People would object to a reduction in the bond. At this point, the defendant is charged with a series of very serious criminal offenses, and the offenses themselves warrant the bond to remain where it is.
Charges here, I think there's 6 counts.
There are 6, Your Honor, yes.
There are 6 counts of felonies here, including 2 counts of assault with intent to murder. And then the remaining counts all involve the use of a firearm. This is also, as you indicated, a defendant that has a prior criminal history. I think that the risk of the safety to the public is high in this matter, and the court believes that the magistrate's order on bond is fair and reasonable under the circumstances, so your motion to amend bond is denied. Any additional matters for the record?
Nothing for the people, thank you.
Nothing for the defense, Your Honor. Thank you.
Thank you. You're all set for today. Mr. Burton, you're free to go. Okay, Mr. Abbott, I thought I saw him come back.
Thank you, Your
Dakota
Honor.
Martin. Dakota Martin is present. Who is in the jail? Sir, what's your name?
Mr. Crabtree?
I'm not sure I heard.
Crabtree, Your Honor. Jeremy Crabtree.
Got it, thank you. You're
Yes,
on both,
sir.
right, sir? Okay, you ready on both?
Yes, Your Honor.
Very good. Okay, we'll do Dakota Martin first. We're on the record in the matter of the people of the state of Michigan versus Dakota Martin. This is file number 21-03058. Have the appearance counsel.
Good morning, Your Honor. Theodora Eisenhut on behalf of the people.
Good morning, Your Honor. John Abbott representing Dakota Martin this morning. He's present by video in jail.
Thank you. Mr. Martin, you can hear me?
Yep.
Okay, thank you. Today's the date that was scheduled for preliminary examination. Actually, it's probable cause conference. Is that correct?
Yes, Your Honor.
Yes. How are we proceeding on that?
Your Honor, it is my understanding both parties are requesting that the matter stay set for preliminary examination next week. I have indicated to Mr. Abbott that I will provide him with a proposed protective order for the forensic interview in this case. I believe that is the only outstanding discovery, and I will get that done this afternoon.
That's correct, Your Honor.
Okay, this matter will continue to examine. It's scheduled for next week, Wednesday at 8:30 in the morning, okay?
Okay.
Any additional matters for the record?
Not from the people, Your Honor. Thank you.
Not from the defense. Thank you.
Thank you, Mr. Martin, you're all set. Thank you.
Thank you.
On the record in the matter of the people of the state of Michigan versus Jeremy Crabtree, file number 21-03072, counsel appearance.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. John Abbott with the Ingham County Public Defender's Office representing Mr. Crabtree. He is present by video.
Thank you. And today's the date that was set for a probable cause conference. Are we continuing to examine this one?
Yes, Your Honor.
Okay. Any additional matters for the record?
Nothing for the people, Your Honor.
Nothing for the defense. Thank you.
Thank you. You're all set for today, Mr. Crabtree. We'll see you next week for your exam.
Thank you.
Thank you. Okay, Mr. Blackman.
Morning, Your Honor.
Was that with you?
That's Miss Kaufman's is with me. Miss Yoder's also outside in my office too.
Okay, very good. On the record in the matter of the people of the state of Michigan versus Caitlin Kaufman, file number 21-02374. Counsel appearance, please.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Your Honor, Fred Blackman on behalf of Miss Kaufman. She's seated to my left, the court's right, at my office, and we have no objection to Zoom for sentencing.
Today was the date that was scheduled for a preliminary examination. However, there was also a matter of a PA 53 violation.
Your Honor, Ms. Kaufman, if I read it correctly, is scheduled for a sentence and restitution hearing and PA 53, not a preliminary examination.
Oh, you're correct. Do I have some?
And Your Honor, I expect the victim on the PA 53 to be here. My apologies, having been in here, I have not been able to call the hall. If Your Honor would allow me to do that very quickly, I can alert the status.
Thank you. In the meantime, Mr. Blackman, did you get a copy of the pre-sentence report?
Yes, I did, Judge.
Okay, we're off the record while she checks for her victim.
For Melvin?
Nia Naglon?
Yes, Your Honor.
Okay, let me find the file. She's been appointed counsel. You see-
I sent them my paycheck stubs. They said that was what was holding them up, and then I never heard from nobody again.
Okay. Mr. Feigelson or Mr. Abbott, is there any way for you all to look up and give me a status on Nia Nalon?
Yes, Your Honor.
Thank you. Okay, they're gonna look it up. I'll call your case in a minute, ma'am.
Your Honor, is there anyone in the court's waiting room?
There is not.
Okay, then I do not have a victim on the PA 53, Your Honor.
Very good. We're back on the record in the matter of Caitlin Kaufman. And this matter was set for sentencing today. The court does have a pre-sentence report and recommendation. The attorneys have received a copy of that. Is there a reason to make any changes, additions, or deletions?
Your Honor, on behalf of the defense, the only change we'd ask Judge is at the bottom of the first page when it says employment data. She is, if I can explain to the court, she has been able to contact this cable, and she's going to be going to work for them. She's in training for the next 2 weeks, but will start in 2 weeks at a job.
Okay.
And we did, and it's by, and the job judges by, would you tell me it's by? By commission, so we won't have a figure for you about what she's earning, Your Honor, at this point.
Okay, where is she gonna be starting?
She's gonna be starting, I think it's out of Flint, is that correct? Oh, it's out of Saginaw, Your Honor. It's gonna be cable for cable TV as a cable technician.
It's in Saginaw?
Yes.
Okay. I've updated the report to indicate that for the information. Any additional changes?
No, Your Honor.
Okay, did you want to address the court prior to sentencing?
Thank you, Your Honor, if I can, real briefly. I've gone over the report. I've talked with my client report. I think she's expressed what she and I have talked about, and what she talked to me about remorse for doing what she did. The owner of this car did not need that done to her based upon this, I guess, quote unquote, three-way relationship that was happening at that time. My client's moved on from that, and we'd ask the court to consider adopting the recommendation. Your Honor, I just got the pre-sentence report yesterday and emailed it to my client. She came in early this morning. We talked about it. Judge, the only thing I'm asking is, the court can order restitution, but I'd be asking for maybe a hearing 60 days down the road, just on restitution, so I can at least take a look at this and make some calls or investigation on that in regards to the restitution issue.
Okay, you want a restitution hearing? You said how far out?
About like 60 days. Is that okay with the court?
It's a little far for a restitution hearing. What is it that you're looking into that's gonna take 60 days?
Well, Judge, I'm gonna be looking at the value that they indicated on the car, and also she's indicated that she lost employment, and some other things that I don't see a monetary issue with that either. If the court wants to have it quicker than that, that's fine.
Okay, the report states that there's a value of the vehicle in the amount of $2,439. Was there another area of restitution that was being sought?
Judge, what we're going to be looking at is whether or not that particular vehicle, and what type of shape it is, was in. I'm going to go to whoever valued it and talk with them about, with our expert, and see if that is in fact a good value for that vehicle at the time. And that would be only that, Judge.
Okay, thank you. We can reset it. We can set this for a restitution hearing. I don't think it needs to be set 60 days out.
Okay, that's fine, Judge.
Any additional things you want to state before the court proceeds with?
No, Your Honor. No, Your Honor. Thank you.
Okay, and is your client seeking to make a statement at all today?
Yeah. Okay, yes, she'd like to talk. Go ahead. Talk loud. Okay.
I have been going over in my head about the situation, and I am remorseful, and I was wrong for what I did.
Okay, did you pick that up? Did you hear?
No, I didn't hear it.
She needs to repeat that. We couldn't pick it
Yeah,
up
you
on the
need to
recording.
speak real loud. Now get up close and speak. And
I've been going over in my head what happened, and I am remorseful, and it should have went a different way instead of ending up the way it did.
Okay, thank you. The court's had an opportunity to review the pre-sentence report and the recommendation of probation. The recommendation is for you to complete a term of 9 months probation and pay restitution. You would benefit from some anger management. So the court is going to adopt that recommendation. I'm glad that you're remorseful, but we want to make sure you have skill sets to help you make better decisions in the future. Should you find yourself in another situation similar to this. So the court is going to impose 9 months probation. During probation, there's a $30 per month oversight fee you're responsible for. You're not to have any contact with Dakota Martin or Monica Bryan while you're on probation. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapons of any kind while on probation. You're not to use or possess alcohol, marijuana, or controlled substance without a valid prescription. You need to submit to random PBTs in your analysis, and you're going to be paying the fees associated with that. Okay, ma'am?
Yes. Yes.
I'm going to order you to attend anger management group. You have obtained employment. I'm going to order that you maintain that employment during this time. We'll set this matter for a restitution hearing before restitution will be ordered.
Can do December 28th.
December 20th at 1:30 will be the restitution hearing.
thank you, Your Honor.
No problem. As to fines and costs, there's a $75 crime victim right fee and a $50 state minimum cost that will be assessed. I'm going to waive any discretionary fines and costs right now because you'll have a hefty amount of restitution likely that you would have to pay. If you were here in person, I'd give you this advice of rights for probation. States here that you have the right to request a hearing for early discharge from probation. Once you complete half the original term ordered by the judge, you must file a motion for early termination of probation with the court. You get that information or that document from your probation officer once you are at that point. You cannot request a hearing for early discharge until all rehabilitative requirements have been completed and there's been no violations of probation within the 90 days preceding your request, okay? Is that a yes? You understand?
Yes, ma'am.
Okay, thank you. You have the right to retain or hire an attorney to represent you at the hearing. You do not have the right to court-appointed counsel for a hearing for early discharge. Lastly, if you are on probation for domestic violence, stalking, CSC, human traffic violations, or an offense where the defense was asserted of guilty but mentally ill, you are not eligible for early discharge from probation. Do you understand, ma'am?
Yes, ma'am.
Okay, so that last stipulation there doesn't apply to you. So at about 4.5 months in, if you had no violations and if you completed your anger management group, you can file a motion with the court for early termination or from your probation status, okay?
Yes, ma'am.
Okay, you have any questions today?
No, ma'am.
Any additional matters for the record? Counsel,
Pardon me, Your Honor, I'm sorry.
any additional matters for the record?
Nothing for people.
No, Judge. No, Judge.
Thank you, you're all set.
Thank you, Your Honor.
You're welcome.
Okay, you're gone. You're gone. I'm gonna get Miss Yoder to Judge. I'll have her sit. We'll wait for you on that too.
Thank you. Okay, do we have an update on Ms. Malon?
Yes, Your Honor.
Oh. Gotcha.
we were here on the 4th of November. I re-interviewed Ms. Nailon at your request and resubmitted a court-appointed attorney request. I've been informed by my superiors that her request for a court-appointed attorney is denied.
Okay, and that's because she makes too much, is that why?
I'm not sure. I think that's what it is.
Okay. So Ms. Nailon, your request for court-appointed counsel has been denied. It's not clear if that's because how much you make. If you should follow up with them to get further information or try to appeal that determination, okay?
I have a question for you. I already have a court-appointed lawyer on a different case. Could he be my court-appointed lawyer for this case? Because how am I denied for this one? And then I have a court-appointed for a following case.
That's a great question, Your Honor.
And that's a great question. Could we get an answer on that?
And I don't understand it myself. She is, Your Honor, represented by Luke Goodrich and by Jared Austin on a couple of other cases. I don't know why this request was denied.
Okay.
And I was still working the same 2 jobs when I replied for those things, so I'm kind of confused on what's
Has your
going
income
on.
changed?
No, ma'am, my hours actually has been cut.
Watson.
Okay, well, we need to speak to Mr. Watson.
Hey.
Okay, I'm gonna request that they reevaluate the denial because you are represented by that office on other matters. So it makes no sense that you will qualify as indigent for that purpose, but not for this, especially if your hours have been reduced. So we'll follow up. Mr. Watson's scheduled to be here this afternoon. I'll make sure I ask him about that. Okay, ma'am? I'm gonna set your matter. I'm gonna reset your matter so that when you can appear and we can follow up on that application.
All right, thank you. I appreciate it.
No problem.
I'm all set for today.
Let me give you a new date.
Okay.
Yeah, November 24th is only for urgency. Wow.
We can do December 2nd.
December 2nd, at what time? 1. At 1. We're gonna reset your PCC for December 2nd at 1 p.m. Okay, ma'am?
All right, thank you. I appreciate it.
Thank you. You're all set. Any other clients here?
You. If you're not in the room, Your Honor.
Okay. And Mr. Blackman, who is with you now? You said Yoder?
Amy Yoder, Your Honor, we're going to be pleading to a misdemeanor. We emailed over the advice of rights and the plea agreement this morning.
This is APA Natalie Maycomer.
Okay.
I've texted her to let her know she is in another matter at the moment. So if we can just hold off and as quickly as she can jump on Zoom, she said she will.
No rush.
Thank you.
Listen to it until 9:30. The APA has not appeared yet. We're gonna wait for her to log in. Okay, what do we have?
We have a quick, probably a bench warrant.
Okay. Okay, you're on Ball? Ball is not present and he is no longer in custody.
That is correct, Your Honor. He's no longer in custody. Wayne County released him, but it does not appear he's paid our bond.
I'm sorry?
It doesn't appear he's paid the bond for our county, but Wayne County released him.
Okay.
And then he also did not appear today.
We're on the record in the matter of the people of the state of Michigan versus William Lawrence Ball, file number 21-02692 FY, counsel appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Piper for the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Ball.
Today was the date that was set for a PCC. Last week we were here and Mr. Ball was not brought over by Wayne County, and then they notified that he was released to Detroit Rescue Mission. And records indicate he's not posted his bond, which was set at 20,000, 10% with GPS tether. So the court will issue a bench warrant and bond forfeiture.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, you're all set.
He actually has two cases. Did you want to call the other case?
Yes, Your Honor, I was going to note that he's on the docket as well in 21-02869 SM, the state pretrial. Aaron Housefield on behalf of that file. The court set the pretrial today with the PCC, I think hoping that he may appear and we could address it.
Okay. I have that file here. A bench warrant will issue on that matter as well.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, you're all set. These do not need to be in the 48-hour hold, they need to be issued. Okay, who do you have?
Aaron Margos, Your Honor, present in the courtroom.
Okay. Mr. Margoshian, you can come up.
Thank you, Your Honor.
On the record in the matter of the people of the state of Michigan versus Aaron Margoshian, file number 21-02502, counsel appearance.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Margoshian.
Today's the date that was set for sentencing. The court does have a pre-sentence report and recommendation. You got a copy of that?
Yes, Your Honor. Mr. Margoshian and I have gone over it, Your Honor. There are no additions or corrections to the body of the report.
Okay, did you want to address the court prior to sentencing?
Yes, Your Honor. Thank you. Mr. Margoshian stands here before Your Honor. He hasn't been in trouble in a while. Your Honor, obviously made a poor decision here. That day does have, issues with substance abuse, Your Honor. From his meeting with probation, they are not recommending that he's a good candidate for probation, Your Honor. He does, or at least he had a worker with CMH. That's how I was able to get him here today. I was advised he does live at one of the shelters, and I did leave a message there. I believe he's staying at one of the shelters, Your Honor. I would think probation could be appropriate here because he does need some help. I don't know if they think it's appropriate. They're recommending 180 days in jail with credit for 24 days, Your Honor. I'd ask for either one of two things. I'd either ask for probation if Mr. Margoshian is willing to do it to get him the help that he needs. If not, Your Honor, I would ask for a straight jail sentence of 24 days with the credit for the 24 days, Your Honor. Leave that up to what Mr. Margoshian wants or to the court, Your Honor. Thank you.
Thank you. Is he in warrant status in another file? I don't know, it says he had a show, he was supposed to.
one for 20-02.
For what? Okay, he had a show cause on the 26th on that file. Okay. You have a bench warrant, so you're supposed to be before the court back on October 26th at 9:15 for a show cause. I'm assuming he owes a fine on that one.
For the bond set.
For the one that he has the bench warrant on. It's not, it wasn't for a failure to pay a fine.
It says pay $100 by October 1st.
Okay, so you were supposed to pay $100 by October 1st on that file. You didn't pay, and so a show cause hearing was set for October 26th, and you did not appear.
You're saying there was a bond that he posted of $350?
I don't know if that was into this file or into that
It
file.
was probably not on the breach of peace file, but.
Yeah.
It was probably, it was, this bond on this matter was 3,510%. So he probably posted on this one,
Yeah, that would make sense.
but he owes on the other one and he didn't appear for court. That's what I'm concerned about. Where were you, sir?
I don't remember exactly what happened. I had problems. I didn't get the money that I was supposed to get.
Okay.
Something happened. I didn't have the $100.
Okay. When are you gonna pay that $100 on the other file?
I can pay it as soon as the 1st of December is when I get paid.
Okay. I need to have that filed so I can remove the warrant.
Judge, you know, did he post a bond in this file, or was that through a bondsman, you know?
I have a receipt in here that it was a cash bond. I don't know whose name is it.
Because the thought I would have is if that's a cash bond and he posted it and it gets returned to him, he can always move that over to the other file to clear up.
Assume that he's getting that money back. Wouldn't it? He's not been sentenced on this one yet.
Yeah, but he's appeared for court.
Correct, but he may get fines and costs.
Yeah, I guess that's
They'll
true.
be applied.
Yeah,
and then
yeah, I guess that's true. I didn't think about that, sorry.
It's assuming he's gonna get that back.
Yeah.
I'll grab that other file and make sure that the warrant on that is addressed. As to this matter, any additional statements before we proceed with this?
None, Your Honor, but Mr. Martin, do you wish to address the court?
Do you want to address the court?
I'm just sorry this happened and want to put it behind me, move forward.
Okay, what are you doing to move forward? What are you doing for yourself?
Right now, I'm staying at the men's mission and working on getting housing. And just trying to stay away from drugs and alcohol.
Okay, what are you doing to try to stay away from drugs and alcohol?
Working out one day at a time right now. About it.
Well, the court is not confident that you're just trying to take it one day at a time is going to be sufficient long-term to keep you away from the types of substances that you have been engaging in, okay, sir? You need some help. Do you recognize that?
Yeah.
So because of that, the court's going to give you an opportunity to do probation and take or participate in some outpatient substance abuse. Hopefully, we'll be compliant and we won't have to address this in any other matter, but I am going to impose a sentence of 180 days Ingham County Jail with credit for 24 days. I'll suspend it and successful completion of 6 months probation. Okay?
Yes, ma'am. Thank you.
While on probation, you need to pay $30 per month for your oversight fee. You're not to use, purchase, or possess any alcohol, marijuana, or controlled substance unless you have a valid prescription, and you're going to be responsible for paying for any random PBTs and or urinalysis that you need to take while on probation. Okay, sir?
Yes, ma'am.
Do not engage in any assaultive or threatening behavior while on probation. Do not purchase or possess a firearm, ammunition, or weapons of any kind. I don't know if you did substance abuse assessment already. You should have had one as part of this. You did, okay. And so as the fines and costs, is $75 convict and right fee that must be assessed, $50 state minimum cost, $90 assessment fee that's going to be assessed. If you do 6 months of probation, it's gonna amount to $180. Do you have any questions about probation right now?
No, Your Honor.
Okay, so as to your advice and rights for probation, you have the right to request a hearing for early discharge from probation. Once you complete half the original term ordered by the judge, you must file a motion for early termination of probation with the court. You cannot request hearing for early discharge until all rehabilitative requirements have been completed and you have had no violations of probation within the 90 days preceding your request, okay?
Yes, ma'am.
You have the right to hire or retain an attorney to represent you at that hearing. You do not have the right to court-appointed counsel for a hearing if you need one for early discharge, okay?
Okay.
And if you are on probation for domestic violence, stalking, CSC, human traffic violation, or an offense where the defense was asserted of guilty but mentally ill, you are not eligible for early discharge from probation. So I'm putting you on a term of 6 months. If you go 3 months, 90 days with no violations and you've completed your outpatient substance abuse, you can file paperwork with probation to get to me to review so that you can be discharged early from probation, okay? Do you understand that?
Yes, ma'am.
Okay, do you have any questions?
Ma'am.
Any additional matters for the record?
None, Your Honor, thank you.
Okay, actually, this bond, was that bond in your name, sir?
Yes.
Okay, so I will have that bond, $100 applied to your other file that's in warrant status. The remaining balance will be applied to this one. Okay,
Yes, ma'am.
Thank you, Your Honor.
thank you. You're all set.
Thank you.
You're checking down the probation, Your Honor?
Yes, please.
Sam, see. Wait, this paper will get you down there. Thank you, Your Honor. Have a good day.
Thank you. Have a good one.
If I don't see you, have a good holiday.
Same to you.
Same to you, Southfield.
Thank you, you as well.
You give me the file number that he has a warrant on. 2007
No, Austin isn't in here. I'll run the halls, you got stuff to do. I'll find it. Yeah, no worries.
Hours is there.
Hmm?
She showed up.
You think we'll do that next?
I don't know. I'm gonna run another one. Is your guy custody?
Nope, she's in the
Okay,
hall.
got it. There's one that we're running with in custody, so whatever order the court wants to do it in. I know Adam and Austin have an adjournment request, so.
Oh. Armistead, Leisha Armistead, did she come today?
No.
She doesn't have an attorney for this, right? She's not, okay. I don't think she want her. I think she want. Okay. Robert Lee Brown, Mr. Keithley was here.
Yes, Mr. Brown is in custody, Your Honor. It is my understanding that he intends to run.
Okay.
If people do have appropriate witnesses and could proceed. I think Mr. Keithley was going to go advise him that I said I would run the case victim list. I just received a message from Ms. May Comer. She's still stuck on the other matter, but hopes to be finishing up very quickly and will jump on Zoom.
Sounds good.
We intend to run Hopkins, Your Honor.
What about Hale?
Hale is Mr. Pfeiffer's case, Your Honor.
Okay.
Mr. Pfeiffer was just trying to grab Mr. Austin. We have to address Burbridge.
Sounds good.
And that's kind of
Who's
where we
also in
are.
custody? Are we running Hale? Corey Hale.
Court Hill.
Yes.
Juan Lopez.
That is me as well.
Are you running that?
On that.
Yeah,
Running?
we're running.
Run it?
Yeah.
Got a lot of running to do. We gotta get started.
Yes, Your Honor.
Okay, I'll let me know about Corey Hill. I did mark it over again. Zarka. Busy today, Mr. Abbott.
Zarka is in custody, Your Honor, and there's an offer from the prosecutor I'd like to relate to him. If I could get on Zoom and speak with him whenever he becomes available. It would be great.
Oh, sounds good. So we'll have the jail put him on. Did they give you a radio today? Or did she have a radio? Okay, we'll see. We'll have her contact the jail to get Zarka on. And you said you need to address Burbridge?
Yes, Your Honor. But that requires Mr. Austin, and
able to
we think he got pulled into somewhere else.
Sounds good. And then we're waiting for Ms. Maycomb on Yoder. Okay, well. We'll see if I can follow up on this one while we do that.
For what it's worth, Your Honor, Brown is going to be, I anticipate, very short. And I know that's the only matter Mr. Keithley is here on today, so he's not, oh, he was going to go talk to him. I'm sorry. Never mind. I thought I could get one done quickly for us.
Is there any chance Zarka is actually downstairs in lockup?
It's noted here that he's in custody.
Okay, I'll go downstairs and talk to him.
Sounds good.
We'll leave this up here because it's the only place the internet works today.
Okay. Alright, so Brown we're running. Burbridge. Okay.
Is that a once a year mandatory training?
Yana, may I approach to give some exhibits to be marked?
Okay.
Thank you.
Which one?
For local.
Hi, these are on Hopkins. Oh. Have I marked them for you? Thank you.
I'll file. I have someone contact.
All right. We continue to my detective and the Mr. Ferris.
on all of them. Hey, Trino's sister Monica, she used to be married to the gentleman. Divorced. No, you're right. Young. She newcomer started out court appointed attorney. I got her before. Yeah, and I had to do my own case. She was so retarded. I mean, anything about your students coming up with scholarship. There's a lot of state there. I wouldn't. True enough, there, that's gonna know two males, but it's scary. Well, one the cops came up and said that they feel that they're on campus. What I don't know. Oh, that's what Mr. Green said. You remember, I know who you are. I know who you represent and what you did. Every one of them. That's what I told you. And I did. We have such fun. Every one of them. I know for a fact. You tried to get me. I'm also working with Tina. She's human sources.
Really?
Yeah. So I have both of them. And they say against them. That's what they for them. Investigation was over 2 hours, and they left me in the rain. And in fact, I kept telling them I had to do this.
Oh, that's right. You told me that.
Yeah.
We're gonna look into that.
The judge was really there. Big 4 days. And she wrote it down. The signs and money. I know. Notice what's going on. Oh, listen to this. If you go look around, everybody's hiring. $15 an hour. Look at the chapter.
Your Honor?
Yeah.
I just received a message from Ms. Maycomer. She's unfortunately still stuck at the 30th Circuit Court. I have a copy of the plea sheet, and I'm able to stand in and do that plea. I know Mr. Blackman has a hearing in Eaton County that he's attempting to get to, so if the court would be agreeable, I can stand in for Ms. Maycomer.
Okay, sounds good. For the record, in the matter of the people of the state of Michigan versus Amy Yoder, file number 21-02268FY, council appearances.
Thank you, Your Honor. Erin Housefield on behalf of the people.
Your Honor, Fred Blackman on behalf of Ms. Yoder. She's seated to my left in my office.
Thank you. Today was the date that was scheduled for a preliminary examination, but there's going to be a plea. Can you place the offer on the record, please?
Yes, Your Honor, thank you. The defendant is going to plead guilty to an amended count 1, animals abandoning cruelty to 2 or 3 animals pursuant to 750.504B. In consideration for that plea, Your Honor, I do believe that should be an amended count 2. I'm sorry, Your Honor, count 2. Is there one charge in this matter?
There was one count, so you're adding a count?
Yes, thank you, Your Honor. So she's going to plead to an added count 2 of the abandoning cruelty to 2 or 3 animals pursuant to the statute that I listed. In consideration for that plea, Your Honor, the people would move to dismiss count 1. There's a Killebrew agreement, Your Honor, to no further upfront jail, so long as she agrees to not own, possess, or reside with any animals without the express permission of the court. And if she participates in a psychiatric evaluation as allowed by statute, and any other additional terms deemed appropriate by this court at sentencing. Your Honor, I can look that up. I believe that it is I'm sorry, Your Honor, the court will give me just a moment.
Aaron, I can give you the penalty if you need it.
Thank you.
Yes, Your Honor, the penalty for that is 1 year. It's a 1-year misdemeanor, Your Honor, a fine of not more than $2,000, and the community service not more than $300.
That is correct, Your Honor.
Okay, so Mr. Blackman, that recitation of the plea is accurate?
It is, Your Honor. Thank you.
Okay, Ms. Kaufman, how are you today?
Fine, thank you.
Okay, and the plea that was just stated here on the record, that's what was offered to you? That's what you recall?
Yes.
Okay, and you wish to accept that today?
Yes.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can put your hand down. There you have the right to be represented by counsel, and you are represented by Mr. Blackman. You have the right to proceed to a jury trial in this matter. You have the right at the time of jury trial to have the prosecution bring sufficient evidence to prove each element of the charge being brought against you. They need to prove each element beyond a reasonable doubt. Do you understand that?
Yes.
If you want to plead guilty to the added count 2 of animals abandoning cruelty 2 to 3 animals, you would have to give up your right to have a trial of any kind. Is that what you want to do?
Yes.
Okay, so that means you will not have a trial. That means you won't have the opportunity to cross-examine any of the witnesses the prosecution intended to call. You won't have the opportunity to remain silent at trial and not have silence be used against you. And you'll give up the opportunity to call any witnesses that you intended to call to further any defense you had at trial. You understand that?
Yes.
Has there been any promises made to you to get you to waive your rights here today?
No.
Is anybody threatening you to get you to waive your rights?
No.
Are you currently on probation or parole?
No.
Okay, you understand that if you were, that a guilty plea could result in a violation of your probation or parole status? Do you understand
Yes.
that? Okay, you understand that a criminal conviction of this kind could cause you to have to report a conviction to your current employer or your future employer. You understand that?
Yes.
There's a Killebrew agreement here, but you're not to serve any further upfront jail. Excuse me, and there's also an agreement that you will no longer own any animals unless you get the express permission, and you must undergo a psychological evaluation per the statute. That Killebrew agreement is between you and the prosecution. The court's not a party to that. So at the time of your sentencing, if the court is going to deviate from that, I'll give you an opportunity then to withdraw your plea, okay?
Okay.
Okay, and are you pleading guilty because you believe you are guilty, ma'am?
Yes.
Okay, as to the added count 2 of animals abandoning cruelty to 3 animals, how do you plead?
Guilty.
On a factual basis.
Thank you. Let me take you, Amy, let me take you back to July 23rd to the 25th of this year. Were you living at on Rundle Street in the city of Lansing, Ingham County?
Yes.
All right, state of Michigan, correct?
Yes.
All right, did you have at least 2 animals in your possession? Is that correct?
Yes.
The result of, now I'm going to ask you concerning your house. Your house was very, very cluttered. Is that correct?
Yes.
And was there a number of items of food that were left out and possibly spoiled in that house? Is that correct?
Yes.
Did your animals have free reign in that house to be able to maybe even consume that, or something might happen to them as a result of the conditions that were really bad inside your house?
Yes.
And so you would agree that at that point, using the term being cruel to your animals, but that kind of was cruel to your animals, the condition of the house. Is that correct?
Yes.
Your Honor, I have no further questions.
Madam Prosecutor, any additional questions?
No, thank you. I know the people are satisfied.
The court is also satisfied with the factual basis, and I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be January 3rd at 8:30 in the morning. Prior to sentencing, oh, actually, Mr. Blackman, does that date work for you?
Yes, it does, Your Honor. Thank you.
Okay. And that could be via Zoom if all parties consent.
Your Honor, the
Yes,
people
Your
would consent.
Okay.
We would, Your Honor.
So-
Your Honor, for the record, if I might, my client has already gone to CMH, has gotten a mental health assessment, and then she was referred to counseling and is in counseling right now.
Okay. I will note that here in the file, and any additional information to support that can be provided to probation, okay?
Yes.
Okay, so prior to sentencing, ma'am, you're gonna have to meet with probation so they can provide the court with the pre-sentence report and recommendation, okay?
Okay.
You should report to them in person within the next 48 hours, okay? They're right here in the
Okay.
courthouse, 5th floor.
Okay.
Okay, in your report, they'll give you some paperwork to complete, to finish your pre-sentence report. Do you have any questions today?
No.
Any additional matters for the record?
Nothing for the people, Your Honor. Thank you.
Nothing for the defense, Your Honor. Thank you.
Thank you, Mr. Blackman, and thank you for your patience. Okay, Mr. Lopez. On the record in the matter of the people of the state of Michigan versus Juan Lopez, file number 21-02696, FY, counsel with parents.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
Good morning, Your Honor. Attorney Randall Levine on behalf of Juan Lopez, who's present and standing behind him.
Thank you. Today's the date that was set for a preliminary examination. However, my understanding is a motion to adjourn.
Yes, Your Honor. Regrettably, the people do have to ask for an adjournment this morning as Officer Kendall is at a once-a-year mandatory training for his job in the police department. Additionally, the detective we would be bringing for evidence of jail calls for initial witness interference charges is currently very sick at home, and they're awaiting a test to see if that illness is COVID or not.
You said Officer
Candle,
Handle.
Kandel. And while I had hoped I would be able to get Officer Candle away from the training for this examination, upon corresponding with him today, as of 30 minutes ago, it's unable to do it in any kind of timely manner.
Okay. Counsel.
Yes, Your Honor. So this would be the second adjournment, and I understand this is entirely not on the prosecutor, but it would be the second adjournment, and the date and time for this hearing was already established. And to the extent that there is a one-time-a-year training, I would imagine that there is a foreseeable amount of scheduling issues that could have been resolved well before the day of. And with that said, the defense is ready to proceed, and again, it would be the second adjournment. So on behalf of my client, he would ask that the matter get dismissed.
Your Honor, in response to that, I would merely note the first adjournment was due to jail calls the defendant made to the victim.
Yeah, I do have that notice or noted here in my file that there was a request due to possible victim or witness interference. And some information was placed on the record at that time. The officer was properly notified to be here, but apparently had a conflict. This could have been resolved by us seeking a new date for now, for the day of. Do you have other witnesses here?
No, Your Honor. The other witness, the victim, Maria
detective.
Salas, is not here again.
And he said so.
Yes, Your Honor.
The court's going to grant a request for your adjournment because the officer is in training and the other officer being sick. I'm assuming they'll be available next week.
Yes, Your Honor. I'm very hopeful the detective will be well by next week, but at the very least, the officer will not be in the training.
Okay. The detective is for the phone calls or for another?
For the phone calls, Your Honor.
Okay.
That is he would be laying the foundation that the phone calls will be entered through.
So if he's so sick, you can file a motion or submit to the court a request to have him appear via Zoom.
Thank you, Your Honor. I think that
The
would work
other,
well.
the officer should be here in person. We're gonna set this for the 24th at 9 a.m.
Thank you, Your Honor.
Any additional matters for the record?
Not for the defense, Your Honor. I appreciate it. Thank you very much.
Okay. And are we ready on, they're not waiting for a matter, are they? Go in the back.
I believe they're here.
Back to people in the back row.
Okay, sounds good. Okay, are we ready on Mr. Brown?
Yes, sir.
On the record in the matter of the people of the state of Michigan versus Robert Lee Brown, file number 21-02983FY, counsel appearance.
Thank you, Your Honor. Aaron Hopkins on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Robert Brown, who is present in the courtroom to my right.
Is the date scheduled for preliminary examination, and we are proceeding. Any preliminary matters before we call our first witness?
Nothing for the people.
No, Your Honor. Thank you.
Call your first witness.
Thank you, Your Honor. The people would call to the stand Officer Erica Halfman.
You come up to the stand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do, Your Honor.
Thank you. You can have a seat there. Can you please state your name and spell it for the record?
So the Officer Erica, ERICKA, last of Halfman, HAL, F as in Frank, MANN.
Thank you, counsel. You can proceed.
Thank you. Good morning, ma'am. Could you please state your occupation for the record?
Police officer,
And who are you with?
Lansing Police Department,
How long have you been with the Lansing Police Department?
Just over 5 years.
Were you on duty on October 28th of 2021?
Yes, I was.
And what did your duties that day include?
Road patrol responding to calls for service.
And at approximately 1400 hours on that date, were you dispatched to 616 Irvington?
I was.
Are you familiar with I'm sorry, what city is that in?
Lansing.
And are you familiar with the Lansing city limits?
Yes, I am.
And is that location within the city of Lansing, county of Ingham, state of Michigan?
Yes, it is.
And why were you dispatched?
I was dispatched there in reference to an assault.
Upon your arrival, did you speak with anyone?
I did. I spoke with Amy Harrett.
And did you determine Ms. Harrett to be a party involved in the assault?
Your Honor, I'm going to have to object. I don't believe there's a proper foundation for that question.
You want to address the objection?
Thank you, Your Honor. The people intend to proceed with this matter victimless pursuant to MCL 768.27C. In order to do that, the people have to lay a foundation that the offense involves domestic violence, that the hearsay statement was made to a law enforcement officer, that the statement is about the injury or abuse, and the timing and the authenticity of that statement. In order to do that, Officer Halfman has to be able to establish these two first questions in order for the people to lay a foundation and proceed pursuant to the statute.
The objection is
Your
noted.
Honor, I wasn't actually planning to make arguments about 76827C at this point. My objection was specifically, I don't think there was a proper foundation for that specific question. Certainly, I understand 76827C exists. As far as, since we jumped ahead to that, I would be placing an objection at this time to any testimony, at least sort of conditionally offered under 76827C as hearsay. I would just ask the court to take that, admit that conditionally upon, and only actually consider it upon them laying a proper foundation under 768.
Okay.
Well, then if I may address, Your Honor,
Foundation.
the just prior question that I asked the officer was why, I'm sorry, prior to the venue question was why she was dispatched. She indicated she was dispatched on complaint of an assault. It is fair then for me to say, you make contact with someone, is that person a party to the assault? I don't believe there needs to be any additional foundation. It's an appropriate follow-up question to why she was dispatched.
Okay. There's two objections, so I gotta take them separately now. As to foundation, I think your foundation is sufficient. I'm gonna overrule that objection, and I will note the other objection as to proceeding under 27C for hearsay.
To be clear, Your Honor, I'm not objecting to proceeding under 27C relative to hearsay.
Okay.
What I'm
It was
objecting
just
to,
the foundation you were objecting.
I am objecting at this point, we haven't actually laid a foundation that this information should come in under 27C. I would just be asking that any information that is received or purported to be offered under 27C be, I guess, conditionally admitted upon a full foundation being laid.
Right. And that's why that objection was noted, is what I said.
Thank you, Your Honor.
Thank you. Do you recall the question?
Yes, she was, so the Miss Hare that I made contact with was a party that was involved in that incident.
Do you know if she was the caller?
I don't recall.
Okay. And did she indicate to you what happened?
Yes, she advised that she was assaulted.
Okay. And did she tell you by whom?
Her boyfriend.
Do you recall his name?
Robert Brown.
Okay. And did she describe, you identified him, her as the boyfriend. Did she describe the relationship to you?
They've been dating for 8 years.
Okay. Did she, okay, and did she indicate whether or not they resided together?
Yes, at 616 Irvington.
And did she provide information for you with regard to when the assault occurred?
The assault occurred just before the 911 call.
And your dispatch was how close in relation, if you know, to that 911 call?
I don't know the exact time, but it was pretty fast.
Thank you. Yeah, at this point, the people believe that they have laid a proper foundation to proceed pursuant to MCL 768.27C, and with permission of the court, will take the testimony of Officer Halfman, by way of the victim's hearsay statements.
Your Honor, can I voir dire the witness as to, I guess, can I voir dire the witness on this issue?
Okay.
All right. So Officer Halfman, you indicated you interacted with an Amy Herrick, right?
That's correct.
Okay, and she wasn't sober when you interacted with her, right?
Did not appear that she was sober, no.
And in fact, she told you she was intoxicated, right? And you believe that she was under the influence of a controlled substance, right?
Correct.
All right. And you noted that in your report, right?
Yes, I
You
did.
thought that was important to note. And that's because people who are under the influence of controlled substances are less reliable than individuals who are sober, right?
Objection, Your Honor, calls for speculation and is argumentative.
Counsel, you would address the objection.
I'll rephrase, Your Honor. In what way did she appear to be intoxicated?
Ms. Harriet just seemed to kind of been slurring her words a little bit. And I noticed that her pupils were pretty pinpoint at the time.
Did you inquire as to what substance she had been using?
I did.
What did she indicate?
She advised she had been drinking alcohol and taking some pain medication.
I have no further questions on this.
Okay, you were gonna address their
Thank you.
motion to admit or proceed under 27.
Thank you, Your Honor. At this time, we would be objecting to proceeding under 27C. One of the factors that must be met, as far as proceeding under 27C is that the statement was made under circumstances which would indicate its trustworthiness or reliability. As noted by Officer Halfman, this witness was not sober, in fact, admitted to having both been under the influence of alcohol and consuming controlled substances prior to making this statement. This is an unreliable and untrustworthy statement, Your Honor. Therefore, I don't believe proceeding under 27C is appropriate. We would ask that these statements be ruled hearsay and be inadmissible. Thank you.
Counsel?
Thank you, Your Honor. To state that someone is under the influence of alcohol or pain medications is evidence of just that she had consumed alcohol and that she had taken pain medication. There's no evidence at this point that any of those things affected her ability to provide appropriate testimony. If I may, if the court would find it to be helpful in making its determination, I can inquire from the officer whether there were any injuries that she observed that would be consistent with the witnesses or the victim's statement, which may then provide additional indications of trustworthiness for Your Honor's findings.
Your Honor, this was not just simply that she had taken medications or that she had consumed alcohol. This was that she admitted to being intoxicated. This is not simply that she took a prescribed pain medication but was otherwise fine, or that she'd had a drink or two. She was actually intoxicated.
Okay, so I'm gonna overrule the objection. Being intoxicated does not mean that your statements are untrustworthy. If there's other factors that would have allowed or that were brought in to make the court believe that maybe she was incoherent or that she was having an issue with her psychosis and couldn't think straight, that'd be different, but that's not been any testimony provided at this point to support that. So just we're admitting that she's intoxicated and that she's had alcohol and painkillers in her system is not sufficient to deem her as her testimony under 27C to be lacking trustworthiness. So the objection is overruled and you can proceed with your question.
Thank you, Your Honor. Ma'am, in speaking with her, did you make any other observations of her demeanor?
Ms. Harriet was visibly upset and shaken by the assault. She was crying and expressed fear of the accused.
Thank you. Now, before we get into what it is that she advised, was the accused still on scene?
Yes, he was.
And do you see him in the courtroom today?
I do.
And could you please indicate for the court what the accused Mr. Brown, Robert Brown, is wearing in court today?
He's got a blue button-up shirt on with a cream colored shirt underneath and a white face mask.
Thank you, Your Honor. May the record reflect that the witness has identified the defendant?
Any objection?
Can I just brief one here on this issue? You indicated Mr. Brown was still on scene.
Yes.
Did you have any direct interaction with Mr. Brown?
Brief interaction before Officer Schaefer made, or after Officer Schaefer made contact.
No objection.
Identification is noted.
Thank you. And Officer, what is it that Ms. Harrod advised you occurred?
Ms. Harrod advised that her and Mr. Brown got to a verbal argument about some of Mr. Brown's drugs that came up missing. After a verbal argument ensued, Ms. Harrod tried to leave the room in fear of an assault and was locked in the bedroom and then assaulted by Mr. Brown.
Did she describe the assault to you?
Yes.
And-
She advised that Mr. Brown had shoved her down, and in result, she fell into a wall and then fell down on top of a stool. And she advised that Mr. Brown began punching her repeatedly all over her body and pulling her hair.
And did you observe any injuries to Ms. Harrod's person?
I did.
And what did you observe?
I observed a few bruise marks on her arms and legs, and then redness to the back of her neck. She also was complaining of tailbone pain.
But nothing regarding the tailbone that you would have been able to visibly observe, is that correct?
Correct.
Okay. But with what you did see, the bruising to the arms and legs and the redness to the back of her neck, were those injuries consistent with her recounting of the assault?
Yes.
Thank you, Your Honor. I have nothing further for this witness at this time.
Thank you, cross-examination.
Thank you, Your Honor. So you indicated that you saw well, let me go back. Your statement today, your testimony today was that Ms. Harrod stated Mr. Brown pushed her?
Correct.
All right, and that was, he pushed her on, was that on her chest, by her shoulders, by her arms?
She was pushed. She described it being pushed in the chest with both hands.
Did you note any bruising or redness on her chest?
I did not.
You testified today she had told you that I believe you said he punched her in her head, right?
Yeah, in her head. She said all over her body, her head, her arms, her legs.
Did she have any, or do you recall seeing any bruising to Ms. Harrod's face?
I did not.
Okay. Anywhere else on her head?
I did not.
Okay. So she didn't have a black eye.
Besides the
That's
back of her neck.
okay. So you didn't see any bruising on her head.
Correct.
You didn't see any redness on her head.
Correct.
Okay. Now, Ms. Harrod at some point indicated to you that she had gotten out of the room where she was with Mr. Brown, right?
Correct.
Okay. And she indicated to you that she had gone outside, right?
Correct.
And that's because her nephew was outside, right?
Correct.
Did you speak with her nephew?
I did not.
Did you note another individual who was identified as Ms. Harrod's nephew being there?
I believe he was there. I don't know if another officer spoke with him or not.
Okay. So did you see someone there?
Yes.
You did. And that would have been Ms. Harrod's nephew.
Objection, Your Honor. Calls for speculation if the officer didn't speak with that person.
You want to address the objection?
So I'll rephrase. You saw another person there.
Correct.
And that would potentially be a witness to this, right?
Correct.
Okay. So that's and you didn't speak to that.
I did not.
Did you make any efforts to find out who that individual was?
I did not.
have no further questions, Your Honor.
Thank you. Any redirect?
No, Your Honor, thank you.
Thank you. This may be
This
excused.
witness may be excused, Your Honor, thank you.
Officer Hackman. Thank you. You may be excused. Any other witnesses?
Nothing for the people, Your Honor.
Is the defense going to be calling any witnesses?
Your Honor, could I have just 1 second?
Probably. Or at least turn it down. Oh, there we go.
It was on the list.
That's fine.
Okay.
I'm surprised you weren't full. I'm surprised you weren't full.
Sure.
Oh.
My apologies, Your Honor.
No problem. Any witnesses?
No, Your Honor.
Oh, okay, thank you. Proceed to argument.
Thank you, Your Honor. In this case, the defendant has been charged with 1 count of domestic violence, 3rd offense. And it's alleged that on or about October 28, 2021, at 616 Irvington within the city of Lansing, Ingham County, he did commit that domestic violence with the 3rd offense notice against Ms. Harrett. I believe that the testimony today provided by Officer Hackman sufficiently establishes the probable cause necessary for the elements of this particular offense, and would ask that this matter be bound over to the circuit court on the complaint as filed.
At this time, the defense would just leave it to the court's discretion, Your Honor.
There is a date set for a preliminary examination. The burden of that preliminary examination is that of probable cause. So that's probable cause that a crime was committed and probable cause to charge the defendant with the crime. Probable cause requires more than a mere suspicion that a suspect committed the act, but not as much evidence as would be required to be presented at the time of trial. And so we heard the testimony today by way of Officer Hackman under NCL 768.27C, in which she provided the court with information about her report to the address of 616 Irvington in the city of Lansing, Ingham County on October 28, 2021 at approximately 1400 hours, in which she made contact with the alleged victim and Amy Harrett, who gave information to the officer regarding a assault by her boyfriend of on and off 8 years, stated that they reside with each other at the address in which the officers located or arrived to. And the officers noted and testified that there were bruising, that they noted bruising to the alleged victim's arms and legs and redness to the neck, and that the victim complained of tailbone pain. The court believes it's sufficient probable cause to bind this matter over as to count 1. Domestic violence, 3rd offense. This matter will be bound over to the circuit court for further proceeding. Bind over date's going to be December 1st. At a time to be determined by the circuit court. You don't need to appear for court on that December 1st date. It's just the date they're going to get it from this. I'm sorry, that's December 1st. That's just the date that the circuit court will get the file from this court. They'll set your next court date, which will be a pretrial, okay? Did you hear what I said, sir? Your next court date, and it will be in circuit court, and it'll be a pretrial, okay? Do you have any questions today?
Yes.
What's your question?
Your Honor, I don't believe that Mr. Brown has a question at this time.
Okay.
The defense at this time would be making a motion regarding Mr. Brown's bond.
Okay, any additional matters before we do the motion?
Oh, my
Nothing for the people, thank you.
Okay, thank you. You can proceed.
Thank you, Your Honor. Mr. Brown is currently being held on a 7,500 10% bond. Obviously, he has not been able to post that. Mr. Brown is in contact with individuals with the health department and I believe community mental health, and is working and has been working on getting placement at a rehab facility he would like to go into. At this point, as I understand it, he has been in contact specifically with a Derek Miller and has placement at a rehab facility. He would be able to go directly from the jail to a rehab facility, and then would be working on during his period in rehab, being able to have housing separate from that of Ms. Harrett, such that he would be able to abide with the court's no contact order. On that basis, we would be requesting that the court reduce Mr. Brown's bond to a personal recognizance bond at this time.
Sounds good.
Thank you, Anna. Can the court advise, and my apologies, whether Mr. Brown was ordered on a GPS tether at the time?
I don't see that on
Your Honor, I certainly don't oppose if someone is seeking rehabilitation services and has a placement that may be very beneficial to Mr. Brown. I would ask that if the court considers that instead of reducing it to a personal recognizance bond, because he then could enter the treatment facility, stay for 4 hours and decide that he wanted to leave if it wasn't part of a court order, I would ask that if the court consider this, that his bond be modified to order him to remain at the facility until such time as it's determined that treatment is no longer necessary, and upon that, to be allowed to be released with a GPS tether.
Okay, Mr. Peter.
Your Honor, I have no objection to an order that would require Mr. Brown to complete treatment. This is efforts that Mr. Brown is making on his own. He seems sincerely interested in getting treatment. I don't anticipate that being a problem. As far as a GPS tether, I don't know whether that's going to end up creating sort of a Gordian knot of legal issues in terms of his bond when he is released from or completes a treatment program. Your Honor, like I said, he would be getting housing such that he'd be able to abide by the court's no contact order. And I don't know that a GPS tether would be appropriate or necessary at that time. Certainly, as Ms. Housefield notes, he could potentially leave treatment, but if he's under order to do it and he's doing it, I don't know that adding a GPS tether once he's completed it accomplishes anything other than unnecessarily complicating this matter. Thank you.
Okay. What is the facility?
Mr. Brown doesn't have a specific name of the facility. Like I said, he's been working with a specific community health worker. I could try to get that to the court.
Okay,
But I
well
don't
then
have it.
I'm not gonna make a ruling until I get the name of the facility.
Thank you, Your Honor.
Okay, so once we get the name of the facility, the court will address the matter, okay?
All right. Would that be something the court would want to address on the record, or if I can get that facility name to the court, via email or something like that? Would that
We
be
don't need to go
sufficient?
back on the record on that, although if you get it today, I'll be here all day, so
Thank you, Your Honor.
no problem. Any additional matters?
Will the court be addressing the issue of a tether at such time as it makes a determination about a reduction to allow him to enter a treatment facility?
The court is just gonna put this on the record. If I amend the bond to PR for the purposes of him going to a treatment facility, it will be with GPS tether.
Thank you, Anna.
Okay, we're off the record on that matter. Let's see. Did you say we were running Hale? Is that what it said? Or who was it that we were running? Hopkins?
We are running Hopkins, Your Honor. And I believe perhaps Mr. Lopez, but may we address Burbridge first? There are a number of files and we have
Lopez is
located.
Gone, we're not doing Lopez. Well, but that's one we just adjourned.
Okay, thank you. Then maybe just address
Burbridge.
Your Honor.
Okay, we'll have Burbridge brought up. I'm gonna hold it.
Yeah, I have,
Did he say he wanted a transcript?
You got it.
good.
Yeah,
It's a Thursday, I'm 54.
Sorry.
No.
Oh, okay.
Ready for 45 minutes.
Okay, Mr. Austin, which matter you, or you here on Burger?
Sign this one.
Yes, I'm here on the Burbridge matters, Your Honor.
Perfect.
Oh, wait, did he leave? He leave it.
He just signed it right
Oh, he
here.
did, sorry.
Yeah, thank you.
That was just someone else.
one, the record in the matters, the people of the state of Michigan versus Montreal Damon Burbridge. I have file numbers 20-01904, 20-03672, 21-02742, and 21-02606. FYI, council appointments, please.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Montreal Burbridge. He is present and standing to my right.
And how are you, Mr. Burbridge?
Pretty good, how are you, Your Honor?
Can you pull your mask over your nose, please?
Yes, indeed.
Thank you. Today's the date that was set for preliminary examinations on each of these files. There are also 3 PA 53 violations set for today. How are we proceeding?
Your Honor, we're going to need adjournment in this matter, and that is due to the evidence getting to my office yesterday and being turned over to the defense attorney today. After the last hearing where it was discovered that there were jail calls to the victims, and this was adjourned, I immediately got a detective on the case to write up a report and analyze them. That analysis was finished Tuesday afternoon, gotten to me Wednesday morning, and unable to get to the defense attorney until this morning. The defense is in receipt of it. It is jail calls analysis as well as downloads of the video visits that purport to show the defense speaking with the victim, Minnie James. And so because of that, we cannot hold the examination today, nor the P53s.
Yes, thank you, Your Honor. That is adequate as far as the turnover of the discovery and those matters. Regardless, I would not be prepared, would not be fair to me, would not be fair to Mr. Burbridge to proceed on those today, just having received and reviewed the written discovery. There's also some video evidence that I have not had a chance to look or review with Mr. Burbridge. So I would have, I guess, a multifaceted list of remedies I would be seeking from the court. This is the second delay on these cases, Your Honor, that, in my opinion, are not attributable to Mr. Burbridge. Now, simply because there are allegations that he has committed misconduct that are unproven to be true at this point, it is certainly not attributable to Mr. Burbridge that the discovery was just turned over yesterday and just got to us this morning. So I would ask the court to consider dismissing those 3 assault files simply because of those multiple delays. And if the court is not inclined to do that, then I would ask the court to consider reducing Mr. Burbridge's bond because of those delays. I believe he could be adequately monitored with a GPS tether that would ensure the safety of the community.
Thank you, Mr. Pfeiffer.
These delays were caused by one person, Mr. Burbridge. He violated the court's orders as contacting the victims. Because he's making this evidence after charges were filed, the delays can't be attributable to the people. And the reason that it took long for the investigation to be completed as to these additional contacts are because of the sheer number of contacts and the attempts made by Mr. Burbridge to shield this from view. That's why the jail calls involve him telling them to have another woman set up video visits for the victim, Minnie James, which is what was done. They were set up in a different woman's name, which the report analyst shows isn't the person that's on the video, because they checked. The fact that Mr. Burbridge is going to such lengths to obscure his actions is not a delay that's attributable to the people, Your Honor. And given the fact that researchers' delays is that he is contacting the victims, multiple victims of his multiple assaultive felony files, I do not believe that a personal cognizance bond would be appropriate at all in this matter.
Well, I tend to agree with Mr. Pfeiffer on this one. And so I will not be dismissing any of these files due to the time that it took for the detective to review. I think October 22nd, I was told it was at least 100 calls made to witnesses. That's a lot of time and a lot of investigation. I would have imagined it needed. We set this out at this point because we thought that would be sufficient time, but again, we weren't the one reviewing the evidence. So the officers, I have no information to believe that they didn't do their due diligence in acting timely with investigating this information. That information has been turned over to you. It'd be in your best interest to have sufficient time to review that, to formulate a defense for your client. And so the court is going to adjourn this matter for that purpose. Court is also not going to be amending bond. I find bond in each of these files will be set appropriately due to the threat to the victims and to the safety of the community. So we'll get you a new date. Sounds like it's a lot of evidence. Is that what's been turned over?
Yes, Your Honor, it has.
That is correct, Your Honor.
Yep. January 7th? Be set for January 7th at 9 a.m. Any additional matters for the record?
Nothing from the people, Your Honor.
I think on behalf of Mr. Burbridge, Your Honor, thank you.
Thank you. You're all set.
Thank you. Thank you, Your Honor.
Thank you. Okay.
Your Honor, were those prelims at 9 o'clock on the 7th?
I'm sorry, it was at 9 a.m.? Yes.
Thank you.
Thank you. So I have left Corey Hale and Javon Hopkins and James Zarka.
Correct. Hale is running for sure, Hopkins is running for sure, and while Mr. Pfeiffer runs Hale, excuse me, Your Honor, I'm going to go check on the status of witnesses for Zarka so I can advise the court.
Sounds good.
If that's agreeable, thank you.
Oh, wait, who's running? You're in Hale?
Yes, Your Honor.
Okay. Will you let the jail know to bring him up? For the security action plan?
Is it Corey Hill?
Yes.
Can we please have Corey Hill come up to the jail, please, to Simmons?
So the messages that we sent
Keep that part of negotiations. Additional.
Something over my head. So
His head, not yours, but
that's what I meant.
as opposed to another. I'm not gonna worry about that for this, especially since they're not that serious compared to the other contacts I've had for other people. Yeah, it'll be over and done with today for the exam. I don't like having, I just don't often have a lot of choice in it.
Yeah. And it's so common. Those, you ever listen to those calls? It says, we're recording these
Every day,
calls.
John,
We're recording these calls and we're giving them to the police.
I listen to them every day. Last week, I had a guy say, I can't talk on this phone because they're listening and they'll use it against me. But please don't come to court.
Yeah.
They absolutely.
Yeah.
My defendants are often a special breed of stupid. Because it's not stupidity, it's narcissism. And they just think they're going to get away with anything they do. Despite the fact they're in jail at the moment.
Yeah. I don't know.
It blows me away every time.
I've got 3 of those.
Yeah.
And they're all the same kind of stupid phone calls.
Yeah. That's why I kept saying, Jim, all 3 of my guys today all had jail calls. All of them with Captain Monaco, who's sick. The worst day that man could have been sick for me is today.
And it's not just that they call, they basically confess to the crime in the first place. And then
Baby, I won't hit you again.
Yeah.
And the truly weird thing is all of these guys have multiple women. And it blows me away because it's not like an occasional thing. All of my guys have 2 or 4.
Okay, we're on the record in the matter of the people of the state of Michigan versus Corey Hale. File number is 21-02740 FY, counsel appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
Good morning, Your Honor. John Abbott for Mr. Hale. He's present and standing to my right.
Today's date that's set for preliminary examination. Are we ready to proceed on this?
The people are ready, Your Honor.
Yes, I'm ready.
Any preliminary matters?
Yes, Your Honor, I just put the offer that was given onto the record. The offer was that the defendant plead guilty to attempted strangulation and domestic violence 3rd offense. The people will dismiss the larger counts of the 2 strangulations, counts 1 and 2. And then the people to also kill her not to pursue witness interference charges for messages and calls from the jail to the victim before the time of the plea. That offer was going to expire for preliminary examination, which is today. I want to make it clear on the record that he is rejecting that offer.
Okay, Mr. Is that accurate?
I didn't really understand that.
he wants to know people plead guilty to
Attempted strangulation, domestic violence 3rd. We dismissed the remainder, and we would not pursue charges for the witness interference.
If you need some time to discuss that, we can give you that time.
Yeah, I can easily step out.
A couple of minutes, I guess, you know.
Yeah.
We're off the record for a
Simple
couple
enough.
minutes. Thank you. You can be seated. We're back on the record in the matter of the state of Michigan versus Corey Scott Hale. Counsel, you discussed the plea offer with your client. How does he want to proceed?
He's not interested today in taking that offer. Thank you very much, Your Honor.
Okay, and I'm assuming this offer expires after the beginning of this exam. Is that correct?
Yes, Your Honor.
Okay, so we will proceed with the examination. Any other preliminary matters?
Nothing from the people, Your Honor.
Your Honor, the defendant is concerned that the felony complaint that I've got does not have a signature on it. He's concerned that the court may be operating off a felony complaint that has not been signed, which is a popular meme in the jail this month.
You need
Mine's
a
got
new
a signature.
complaint?
My signature.
But signed by the complaining witness, Your Honor.
Our felony complaint is signed.
Yours is signed, Your Honor?
Unless you have a new complaint. The one I have here was signed on September 30th, it looks like, 2021.
Is it signed by the complaining witness, Your Honor, or just by the prosecuting attorney?
Complaining witness signature. I can't read their signature, but it looks like they have a badge number of
Assuming Detective Scatia.
Okay, there you go.
You want to see it?
Yeah, I want to see it.
I didn't tell you to approach.
Oh.
I'm not, and you're not touching my file. Your attorney should have gotten a copy of this information and his should have been signed. Why is yours not signed?
I think they send us the same one that they give to the prosecutor, which is the same one that they bring to the court. And the one that gets signed is the one that you get. And
Okay, is your sign?
Only signed by myself, Your Honor. Again, I believe that's correct, but that the complaint was signed, and that doesn't change
The
anything.
complaint is signed.
I understand.
Oh.
I'm ready to proceed.
Okay, sounds good. You can call your first witness.
Thank you. The people will call Officer Sean Rotuno. He's back in the jury room there.
You come up here. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat there. Can you please state your name and spell it for the record?
Sean, S-E-A-N, Rotuno, R-O-T-U-N-N-O.
You can proceed, counsel.
Thank you, Your Honor. Good morning.
Good morning.
Mr. Rotuno, can you tell me where you're currently employed?
City of Lansing, Florida Police Department.
And what's your role there?
Police officer.
And Officer Rotuno, how long have you worked there?
10 months.
So were you employed in that capacity on August 12th of this year?
Yes.
And on that day, did you have contact with a Melissa Sills?
Yes.
What was the nature of that contact?
It was a domestic violence call.
And was that at 329 South 8th Street?
Correct.
Is that in Lansing?
This is,
To your knowledge, is that in the county of Ingham?
yes.
Your Honor, I will be seeking to move forward under MCL 768.27C. In order to do so, I'll be asking some foundational questions that will elicit hearsay.
Thank you. And place your objection on the record.
Thank you, Your Honor. Well, certainly I object to the hearsay, and I guess after we hear the testimony, I'll ask the court to evaluate it regarding the factors in that statute as to whether it's admissible. Thank you.
Objection is noted. You can proceed.
Thank you, Your Honor. So you went out there for a domestic assault complaint.
Correct.
And you spoke with Ms. Sills.
I did.
Did she tell you about the assault?
Yes.
Who did she say had been assaulted?
I'm sorry?
Who did she say had been assaulted?
She was assaulted.
And did she tell you by who?
Yes.
And who did she say had done it?
She said it was her boyfriend, Corey Hale.
Did you say how long it had been since the assault had taken place? Doesn't have to be exact, just ballpark in terms.
Within the hour. It was my first call of the day.
Did you notice any injuries?
Small injury to her lip, and there was some redness on her neck.
Did she say that during the assault anything happened to her lip or her neck?
Yes.
And did those injuries seem to match up with what she had told you had happened in the assault?
Correct.
Your Honor, I believe there has been sufficient foundation to proceed under MCL 768.27C. The victim specified that this was a domestic assault, that there had been a dating relationship. The officer was working in his official capacity as a police officer. The assault occurred recently in time, and there were corroborating factors to indicate the truthfulness of this, namely the injuries that matched the assault that she had described.
Thank you, and you're continuing your objection?
Continuing the objection until we hear the whole story, Your Honor, as far as those factors of reliability are concerned.
The objection is overruled at this time. You can proceed on 27C.
Thank you. So, officer, can you tell me in a little bit more detail, what did she tell you happened?
So initially they were arguing. She stated that she was yelling at Mr. Hale because he would not do the dishes. At which point, I believe, if I remember correctly, the sequence of events,
Yes.
to clarify, Mr. Hale threw, I believe it was a bowl at her knee, hit her. She said she threw it back. At which point she stated Mr. Hale strangled her, came up to her, strangled her, or I should say, put his hand around her neck and squeezed for approximately a minute.
Did she say if this affected her ability to breathe?
Yes, from my recollection, she said that it was made it very difficult to breathe, but at no point did she lose the ability to breathe.
But because of the pressure, it still made it difficult to breathe.
Correct.
All right, so he strangled her for about a minute, you said. What did she say happened next?
I believe she, if I remember correctly, walked outside to call the police, at which point he walked outside and strangled her again, or sorry, let me rephrase, put his hands around her throat again and squeezed again.
And did she say that this caused impediment to breathing again, second time?
I believe so.
Now, she told you that this was her boyfriend, Corey Hale, who had done this.
Correct.
Did she give any other identifying information about him?
She did give me his date of birth and stated that he lived at the same address as the call took place at.
And so, using that information, were you able to find a picture of Mr. Hale?
Yes.
And would you be able to see or identify him here today, even if he was wearing a mask, or would you need masks to be taken down to make proper identification?
I would like the mask to be taken down for proper identification, just to be certain.
Your Honor, I'm going to be asking him if he sees that man here today. If I could have everybody here lower their masks very briefly.
Everyone, please remove your masks.
So, officer, do you see the man from that photo here today?
Yes.
And can you please identify where he's sitting and something that he's wearing that differentiates him from the other people in the room?
Yes, he is sitting to my left, wearing the blue button shirt with the long johns underneath.
Thank you. If the record could indicate that the officer has identified the defendant.
Any objection?
Your Honor, he's referring to a photograph that we haven't seen yet. That photo's not in evidence. And I'm not sure how he picked that photo out of all the photos that might be available to the police department. I believe there's an insufficient foundation for the photo itself and therefore for the identification.
Do you want to respond?
That's fair. I can ask an additional follow-up question. I believe will provide sufficient foundation.
I will let you further lay foundation. Objection is noted.
Thank you, Your Honor. Now, using this information, the name, the date of birth, the address that the victim gave you about her assaulter, how did you find a photograph?
So I ran him in lean based on his first, middle, and last name and his date of birth. as well as the fact that he is a male. So based on those three identifiers, I was able to come up with a photo in lean, which is I believe, a former driver's license picture, which
And
is what I observed, the photo I looked at.
And the man that you identified here today as Corey Gale matched that photograph.
Correct.
Thank you. I believe that's sufficient foundation, Your Honor.
Further objection?
No further objection.
Identification is noted.
Now, was
Well, the objection's overruled to that extent.
Thank you, Your Honor. Now, was Mr. Hale present when you arrived and spoke with Ms. Sills?
I do not know.
But you didn't see him there that night?
Correct.
Now, you say that you don't know. Why didn't you know one way or the other?
Because Ms. Sills stated that she did not know if Mr. Hale was still in the residence or if he had left.
Did you try searching for him?
We asked Ms. Sills if we could go in the house to search to see if he was still there, because she advised that she did not know if he was in the house or not. She said we could. However, there was another resident who I believed owned the house. And in order to get to the area where we believe Mr. Hale may have been, if he were in the house, there was a common area and he did not grant us access, so we could not go into the house legally. So we were unable to search the house to see if he was there.
I see. So he was in a section of the house that Ms. Sills didn't have authority to grant you entry into.
She did, but because there was a second party there, we needed consent from both parties because it was a communal area.
I understand. And do you happen to remember the name of that individual?
I do not.
Would looking at a copy of your report help refresh your recollection as to that?
Yes, sir.
I object, Your Honor. I don't think reading a name off a piece of paper is actually going to refresh his recollection. He's just going to read the name and repeat the name that he reads. It's not actually his recollection. It's just, can you read this piece of paper?
You gonna respond to the objection?
That's why I asked him if it would help him refresh his memory as opposed to simply reading it off the paper. That's the purpose of the evidentiary rule.
Agreed. The objection's overruled.
Thank you. If I may approach, Your Honor.
You may.
Now, I don't want you to read anything or speak aloud while you're reviewing this. Just please let me know when you're done reviewing it. And it's whether it's either successfully refreshed your memory or it's unable to do so. I'll come and take it from you, and then I'll go back to answering your questions, asking you questions.
Okay. I'm set, sir.
Officer, was that able to successfully refresh your recollection?
So I remember the name, it looks familiar, but to say 100% that I remember who the name on that paper is, I can't say for certain.
Okay. Well, thank you for your honesty with the court there. And that's the point of that, so it's all right. The people have no further questions for this witness, Your Honor.
Cross-examination.
Thank you. Good morning, officer.
Good morning, sir.
So a couple of times during your testimony, for example, when you said that, I believe so, that she said she was grabbed by the throat the second time. How much certainty do you have there? You know, you're looking back at something that happened months ago. So she may or may not have actually said that. Is that what we're to understand?
She did say that.
Okay. And and the assistant prosecutor, Mr. Pfeiffer, asked you, you referred to this as happening at night, but it actually happened during the day, right?
Correct. I don't believe I said that, but
You didn't. He asked it as it was happening. It was in the daytime, right?
correct.
Okay. And it was middle of the morning sometime?
Early afternoon.
Early afternoon? And you and 3 other officers were there?
2 other officers.
Okay. So, and none of the officers that were there saw Mr. Hale?
To my knowledge, no.
And nobody can tell for sure if he was there or not?
To my knowledge, no.
Okay. And other than her giving you a name and a birth date, which you looked up on your lien system.
Correct.
You have no other way of knowing whether Mr. Hale, this person here, was actually at that house that day?
I cannot tell you for certain, no, because I did not see him there.
And she was not treated for any injuries?
No,
And did you notice when she was talking to you that she kept like weaving back and forth and occasionally slightly stumbling? Do you remember that?
not specifically, no.
Did she mention anything about using any drugs that day?
Don't believe I asked her.
You know whether or not she was under the influence of any drugs that day?
I do not.
You didn't test her for alcohol or anything?
No.
Thank you. Nothing further.
Thank you. You rest.
Nothing for the people, Your Honor.
Okay, you may be excused, officer. Thank you.
Thank you.
And you can call your next witness.
The people have no further witnesses, Your Honor.
Is the defense calling any witnesses today?
Not today, Your Honor.
Okay, proceed with argument.
Thank you, Your Honor. From the evidence that's been presented through MCL 768.27C by Officer Rotono about what Melissa Sills told him that day, the people have met their burden for probable cause standard for the preliminary examination. We'd request bind over on counts 1, self-strangulation, counts 2, self-strangulation, and counts 3, domestic violence, third offense. The reason that there are 2 self-strangulation charges is because there were 2 different strangulations. As the officer testified to, she was strangled once, not unable to breathe, difficulty breathing due to the pressure exerted on her neck by the defendant. She then went out to the deck to call police, and then he went outside and did it a second time. Because there was the break in these 2 incidents, it is not 1 strangulation, it is 2. And therefore, there has been enough factual evidence here to meet the burden for 2 counts of assault by strangulation. And ask that you bind over on all the charges.
Thank you, Mr. Abbott.
Thank you, Your Honor. The problem with 768.27C, Your Honor, is that anybody can create a case against anybody else without ever testifying against them. And in this case, no one saw Mr. Hale at that house that day. There's no actual evidence by any eyewitnesses that saw him there. And all we have is this hearsay, which is pretty thin ice. I understand that you can look up somebody's picture and say, well, yeah, if you looked up John Abbott in the Secretary of State, you could then identify John Abbott by comparing the picture to me. It doesn't prove whether I was any place at any particular time. So I'll leave it to the court's discretion as to whether a question of fact has been created on these issues. But in terms of an actual crime being committed, there's very little evidence. You know, the other good explanation for why the lady didn't show up for court on October 28th and didn't show up for court on November 4th and finally didn't show up today is because she made this whole thing up just to get him in trouble. Thank you, Your Honor.
Made the whole thing up, she probably would have been here saying lies, according to Mr. Abbott. She's not. And that's why MCL 768.27C exists, because the legislature recognized the fact and expressly noted that when they made the statute, that in instances of domestic violence, victims often either can't or don't appear because of the power and authority that the defendant's able to exert over them, even while they're locked up in jail. That's why the statute exists, for this exact circumstance. And that is why it requires an element of trustworthiness by corroborating elements at the time that they're speaking with the officer to avoid those situations. And as the officer noted, there were those elements because there was marks to her neck and an injury to her mouth that matched the assault that she described. So I'd ask for bind over on all 3 charges.
Thank you. Today was the date that was set for preliminary examination. The burden for this examination is that simply a probable cause. This probable cause that a crime was committed and probable cause to charge the defendant, Mr. Hale, with a crime. The defendant in this matter has been charged with count 1 of assault with intent to do great bodily harm less than murder or by strangulation. Count 2 is the same, assault with the intent to do great bodily harm less than murder or by strangulation. And there's a count 3 of domestic violence, third defense. We heard testimony from Officer Sean Rotono, and he proceeded to provide a narrative under MCL 768.27C. I understand your arguments and your objections, Mr. Abbott, but the legislation is the legislation. And so those objections were overruled, that testimony was admitted. The officer narrated or described an incident which he reported to the area of 329 South 8th Street, which is in the city of Lansing, Ingham County, making venue in this court appropriate on August 12, 2021, in response to a domestic violence complaint that he made contact with the alleged victim, Melissa Sills, and that description of the incident described an argument that escalated over washing the dishes, and the defendant allegedly threw a bowl at uh, the victim, and the bowl was thrown back at the defendant, and then the defendant proceeded to strangle or place both of his hands around the victim's neck and squeeze. The victim ran outside to call 911, and then the defendant allegedly followed and strangled again. Both reports included impairment to her breathing. She provided the officer with a date of birth, name, date of birth, and the address of the defendant, which was the same address that the victim resided as. They had been in a dating relationship and living with one another. The court is satisfied that there is sufficient probable cause to bind over on counts 1, 2, and 3. These matters will be bound over to the circuit court for a bind over date of December 1st. You don't need to appear in court on December 1st, Mr. Hill. That's just the date that court will get the file from this court. They'll set your next court date, which will be a pretrial. Your attorney will be made aware of that next court date. Okay, sir? Did you hear me? Need you
Yes.
to speak.
Yes.
Thank you. Bond was set at 7,510%. That will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
In the matter of bond, Your Honor, he's been in jail for weeks now. He doesn't have the $750, and nobody else he knows has the $750 necessary to bond him out. I'd ask the court to consider reducing his bond to personal recognizance. The risk of flight is low. He's a longtime Lansing resident. The risk of harm to others is, well, the alleged victim here could be certainly protected by a no contact order. And I'd ask the court to consider a personal recognizance bond. Thank you.
Mr. Carter.
Your Honor, my intention was to have Detective Wanacott here today. As I've said numerous times this morning, he is unfortunately ill, in order to introduce messages that the defendant sent to the victim. I can briefly explain to the court. The quote is, "Hello, Darcy. I'm trying to let Missy know I need her to come to court for me on 10/28 at 9 a.m., 54A District Court. Tell them she didn't tell the truth to the police because she was upset. They will drop the charges and I can get released from here. I can't get a hold of anyone to relay my court date. Please see that you can get this to her. Tell her I love her and miss her, very much thinking of her 24/7. Please let me know you got this message. Also ask Missy to set up a video visit before I go to court." This is in his name, Corey Hale, to Darcy Hun, clearly speaking about the victim, Melissa Sills.
No, it's not saying Missy.
Sorry, so, no.
Oh, he can put whatever he wants on the record. Feel free.
I advise against it.
You have an attorney here. Everything you say is on the record and it can and will be used against you. You understand that, sir? Okay. Motion to amend bond is denied.
Thank you, Your
Additional
Honor.
matters.
Nothing from the people.
Nothing, thank you.
Thank you. Good luck, Mr. Hill.
So you're gonna give me that, just over that. Right?
Yeah. We have to. Along with your list of additional calls.
Yeah, 'cause he's definitely
call on the record in the matter of the people of the state of Michigan versus James Anthony Zarka, file numbers 21-2414 and 21-02420. Council appearance.
Thank you, Your Honor. Aaron Housfield on behalf of the people.
Good morning, Your Honor. John Abbott, representing Mr. Zarka. He's present and standing to my right.
Thank you. Today's the date set for preliminary examinations on both of these files. And I think there's a motion to adjourn.
Thank you. Yes, Your Honor. The people are making a motion to adjourn for a good cause. In file number 21-02420FY, one of the material witnesses is Detective Jennifer Pung. I've just learned approximately 20 minutes ago that she is quarantining and has been diagnosed with COVID. My apologies to the court and defense counsel. If I'd known this ahead of time, I would have alerted someone. Certainly, the people cannot proceed on that file. And given what the people's position is on the interweaving of the two files with regard to the conduct and the identification, it would be the people's position that it would be most appropriate to also adjourn case number 21-02414FY and have them proceed on the same date and time.
Thank you, Mr. Abbott.
Your Honor, we're prepared to proceed today, and we ask the court to not grant the adjournment. I guess if there's one police officer that can make it, I don't know why other police officers couldn't be here. It was investigated by a team of officers, I'm sure. And we're prepared to proceed on both cases. Thank you.
Thank you. Okay, well, Detective Pong is a material witness here, obviously the detective on the matter. And it's currently sick with COVID. So the court will grant the request for an adjournment due to the detective's exposure. And the court will find good cause to adjourn this matter beyond the 21-day timeline. Oh, actually, I think he's already done that. He was arraigned back in August on this file. And on both files, I'm still trying to understand the connection between the two files. You say that they're connected in some way?
She says so, Your Honor.
Oh, well, I wouldn't know. I don't know anything about the facts, so I'm going to take the prosecution's word for it. Both matters will be adjourned to a new date. Because the detective has COVID, we need at least 2 weeks.
Is the 9th too soon?
Is that 2 weeks out? I think it's at least 2 weeks out.
Yeah.
Okay, we'll do December 9th at 8:30. Okay. Any additional matters for the record?
Nothing for the people, thank you.
Bond, Your Honor. Currently set at 7,500, 10% in both files, I believe, and is more than he can afford at this time. He's been in jail for several weeks. He's a longtime resident of Lansing. He's got a family to be with. It's Thanksgiving. I'd ask the court, since it's not his fault, we're adjourning, that he be allowed to.
I will show up, I promise.
He'll come back. I think that's what
You
he
can
said.
put me on tether, anything, I will be here.
Anyway, I'd ask the court to consider personal recognizance so that he can be released back into the community. The risk to the community is low, and there's no allegations of any personal injury or threats or use of weapons. And like I said, he's got a family here in town, and it's Thanksgiving. Thank you.
Madam Prosecutor.
Thank you, Your Honor. I will make the court aware that in addition to these 2 felony files before Your Honor, he has 2 misdemeanor files. They are not assaultive charges. They are also property crimes. When Mr. Abbott says that he's not a threat to the community, he certainly is a threat to the businesses and the public. The charges here are 2 counts of breaking and entering 2 separate buildings. The 2 misdemeanors involve, again, theft, property crimes. I will make the court aware of those facts and then leave it to the court's discretion as to the reduction.
I'm just reviewing these files. It looks like he does have at least 1 failure to appear.
Long time going on.
I'm sorry?
Sorry, I didn't mean to interrupt you.
Okay, I gave you some grace because you've done it multiple times.
Sorry.
Maybe Mr. Abbott can go to lunch and you can just represent yourself since you want to speak and not let him speak. Okay, thank you. So there is at least 1 failure to appear on this file. The bonds are $7,500 on both 10%. Would the magistrate issue these bonds? She at least had the availability of his prior criminal history and any other recommendations that came before her. I find her bond to be reasonable, so I will deny the request to amend bond. Any additional matters for the record?
I think for the people, Your Honor,
Not at
thank you.
this time, Your Honor. Thank you.
That's it.
Thank you.
For your own notes.
It won't print in here.
Oh, it won't, oh.
Yeah.
That's broken.
Offer will stay open, John.
Okay. Oh,
Offer stays open.
I'll just bring it up.
Okay, that's that. And then 1 o'clock, I gotta do garden hire and then we can do Hopkins.
Thank you, Your Honor.
I'll go tell Mr. Hopkins to go eat lunch.
Sounds good.
Right.
Thank you.
Thank you, Your Honor.
And you just on that, they left. I let them know in between, so they should be well clear of the building.
Okay, cool. I'm gonna leave this in your.
Yeah, we're gonna lock the door anyways.
That's okay, because when I walk out of the room, it stops